Hi, everyone. Welcome back to The Break. As you may know, I'm Clare Irvine. I'm PI's Government Affairs Counsel and joined by Brad Lachut, PI's Director of Government and Industry Affairs. So Brad's here today to talk about a truly heroic piece of legislation that is surprisingly not out of a Marvel movie, but the New York HERO Act. So without further ado, I'll turn it over to Brad.
Well done, Claire. That was quite the intro. I appreciate that. Yes, today I'm going to be talking about the New York HERO Act. This is a new law in New York State that is going to require employers to do a couple things. And we're going to address the first part of it, which is develop an airborne infectious disease prevention plan. Very exciting stuff. So let's get right into it. First of all, what is the New York HERO Act? It's the New York Health and Essential Rights Act, aka the New York HERO Act, because every law has to have a clever acronym. This legislation, no surprise, has been kind of born out of the COVID-19 pandemic. The aim is to ensure the safety of employees throughout New York State, that their work sites are not leading to the spread of airborne infectious diseases. So there's two main parts to the law. We're only going to address the one part here for the sake of time and do another break on the second. So the first part is to implement an airborne infectious disease prevention plan. The second part is to allow the formation of employee health committees to ensure the safety of the workplace. Again, we'll get into that in a separate break, and we'll just dive into the airborne infectious disease prevention plan first. So on that plan, hopefully it'll be fairly straightforward. We'll see. So under the law, which was just was signed basically into two parts, Governor Cuomo signed the original part of the law back in May. When he signed it, indicated that there needed to be some amendments made. The legislature then passed what they call chapter amendments, which amended the law. The governor just signed those in June, and now we have a final piece of legislation, final law. So what it says now is that the New York State Department of Labor is required to create a general model airborne infectious disease plan that employers could adopt or follow. Originally, legislation required the Department of Labor to create these plans for every individual industry. That was dialed back. They now have to create a general plan, as well as some industry-specific guidelines if it is warranted. I don't anticipate there'll be ones for insurance producers. We'll probably see a financial services plan, and that'll likely be where insurance agencies fall. That plan by the DOL must be produced by July 5th. That date has also changed, so you might have seen June 4th at some point. That was under the original New York HERO Act, when that was signed in May. With the chapter amendments that were signed, it has kicked the effective date and the deadline for these guidelines to come out to July 5th. So don't panic if you haven't seen anything yet. So once July 5th hits, that's when employers will then kind of have to spring to action. And that goes into what the guidelines are going to be. So under the law that states that the guidelines need to address certain areas. They're probably going to be more expansive than this, but they are at least going to address ththese areas. They include employee health screening, use of face coverings, use of personal protective equipment or PPE, the availability of hand hygiene stations, aka sinks with water and soap, how regularly clean office spaces, shared equipment, things like that. Now, these guidelines aren't going to say people have to wear face coverings or they have to do employee health screenings. They're going to give instances where those might be required depending on the health circumstances that exist. So these aren't going to be hard and fast rules that everybody, some of them I should say, will probably be hard and fast rules that you have to abide by all the time. Some of them will not be. For example, I don't think the use of face coverings will be something we're requiring all the time, although perhaps the regularity of cleaning might be something that needs to be upped. But we'll see when those come out again on July 5th. And when they do, employers will have 30 days from that publication in which to either adopt the Department of Labor's model standards or to develop their own. And if an employer was to develop their own, that plan must meet or exceed what the Department of Labor has put out. There really does not seem to be a compelling reason why an employer would want to create their own guidelines unless you are in a hyper-specific industry or business that has unique risks that you think need to be accounted for. My recommendation would be just to take the DOL's guidelines and adopt them as your own. They're doing the work, might as well just benefit from it. Now, once that plan is adopted, you will then have an additional 30 days to distribute it to your employees. So basically 60 days from the time that the DOL puts out the model guidelines, an employer should have adopted their own and also distributed that plan to their employees. In addition to distribute it to employees, it should be put into an employee handbook if employers have that, as well as being posted around the office in prominent locations where you might have other employment posters and things of that nature. So hopefully, in terms of compliance, this will be fairly straightforward because the Department of Labor is doing all the work. Now, actually implementing what it needs to be required is another story, and we won't know the full extent of that, obviously, until the Department of Labor does release those guidelines. The final thing I'll mention is something that always comes up is, well, what if I don't follow this law? Well, good question. There are some penalties attached and can be fairly significant depending. This one's first one, any business that fails to adopt a prevention plan. Again, the DOL is releasing a model one, so all you have to do is take that model and put your company name on it. Is going to be fined $50 per day if they get caught. So that could add up over time, and also it's really easy to comply. Just adopt the DOL's guidelines. The second part is any failure to abide by those, that prevention plan, those guidelines, could result in fines up to $10,000 per incident. So this could get hugely expensive very, very quickly if you don't take this seriously. So there are some requirements. Hopefully there won't be a pain in the butt. There are some penalties. Those will be a pain in the butt. So make sure you're being aware. We will certainly have another break and some more resources once those Department of Labor guidelines are released. And as I mentioned at the beginning, we'll have one on that second part of the Employee Safety Committee as well. So with that, if you have any questions on this, anything I talked about, either the Safety Committee or specific guidelines, feel free to email myself, Clare, or the Resource Center using the links that you see on your screen. And with that, I guess I'll turn it back over to you, Clare, if you have any questions for me.
Yeah, I think just one quick question is that most people who watch this, if they're an employer, had to adopt some pretty, for some employers, pretty onerous protection measures last year as they started reopening their offices. Do you expect, without reading the guidelines, that they will be anywhere near the level that they were last summer?
It's a great question. So I think that the guidelines will be scaled back, probably won't do as much, and this is my guess, but you also see a lot of similarities. So you might see that, in the event of X, as a COVID-esque pandemic, you are required to do 1, 2, and 3. I guess I'll wear masks, remote work, things like that. So I think you'll see a lot of similarities between what comes out on July 5th and what we've already seen through the New York Forward program that Department of Labor, conjunction with the Department of Health, have put out before. I don't think they'll be as onerous just because we're not in a public health emergency anymore, or at least we're coming out of one. But you'll see a lot of the foundation, a lot of the bones will be similar.
And how long do employers have to have these guidelines as part of their policies? How long will they be?
These policies will be in place in perpetuity. This will be like anything else you put in, drug policy, sexual harassment prevention policy, 2 new things that are required to be put in as well. That'll be in your employee handbook until this law comes off the books, which will likely be never. So make a spot for it and let it get comfortable.
Yep. Okay, well, great. Thanks, Brad. Thanks everyone for watching. Sorry if you clicked on this thinking it had something to do with a Marvel or DC movie. That's a completely different break. Those are really good too. Thanks, everybody. Thanks, Claire.